All right, picture this for a moment. You're home, maybe making dinner, and you look out. Police officers, right there, on your front porch. But they're not just knocking. They've got a specialized tool with them, a highly trained drug-sniffing dog. And it's working, sniffing right at your door, looking for something inside your house. Now, is that okay? I mean, is that just good police work, or is it actually stepping over a line, an invasion of your privacy? That's the really tricky, fundamental question we're digging into today. We're doing a deep dive into a legal fight that went all the way up to the U.S. Supreme Court. The question, is a dog sniffing for drugs outside your home a search that's prohibited by the Fourth Amendment? Sounds kind of specific, right? But the implications are huge.
They really are. And for this deep dive, we're going straight to the source. We're looking at excerpts from the Supreme Court itself, the majority opinion, and the dissenting opinion in the big 2013 case, Florida v. Jardines. This case, well, it really gets to the heart of that constant balancing act, between effective law enforcement and your right to privacy, especially in your own home.
Yeah. Okay, so our mission today. Let's unpack these arguments. Let's try to understand the different legal philosophies, because they really clash here, and see how this question about, well, a dog's nose actually affects your rights today, right now. Okay, let's get into it. So let's paint the picture. What actually happened? The events that kicked off this whole Supreme Court battle, it involved a guy named Jardines, right? And the police suspected he was growing marijuana.
That's exactly right. This all started back in 2006. The Miami-Dade police got an anonymous tip, just a tip saying marijuana was being grown at Jardines' house. So based on that, Detective William Pedraja, along with another detective, Douglas Pertelt, and his drug dog, Frankie, they went over to Jardines' home.
Frankie. Okay, tell us about Frankie. Was he just any dog?
Oh, no, definitely not. Frankie was a trained, certified drug detection dog. So his job was specifically to sniff out narcotics. Detective Bartelt later testified about what happened. He said Frankie was on a 6-foot leash. They walked up towards the front door, and Frankie immediately started trapping back and forth, like he was really trying to zero in on the strongest source of an odor. And then Frankie sat down right at the base of the front door. That was his trained signal, his way of saying, it's here, it's the alert for drugs.
Okay, Frankie gives the alert. What happens then?
Well, that alert was everything. Based pretty much entirely on Frankie signaling at the door, the police then went and got a search warrant for the house. They went inside, found, I think it was over 100 marijuana plants. So Jardines was arrested. He later pleaded guilty, but crucially, he kept the right to appeal. He wanted to challenge the legality of that initial dog sniff, and that became the question for the Supreme Court. Was bringing Frankie onto the porch, was that itself a search under the Fourth Amendment?
Before we jump into the court's answer, maybe let's just quickly recap the Fourth Amendment. It's so fundamental, but what does it actually protect? Why is it such a big deal?
Yeah, it's foundational, right? It guarantees your right, everyone's right, to be secure. Secure in your persons, houses, papers, and effects against unreasonable searches and seizures. The key phrase there is obviously unreasonable searches. Generally, for police to search, especially your home, they need probable cause, and usually they need a warrant issued by a judge.
Okay, unreasonable. But how did courts, historically figure out what counts as a search? Because that seems like the first hurdle.
That's a great question, and it's evolved. Traditionally, the main focus was on physical intrusion. Did the government physically trespass onto a place the Constitution protects, like your house? That was the main test for a long time. But then things got a bit more complex. In 1967, there's a huge case, Cassis v. United States. That case introduced another way to look at it. Did the government's action violate someone's reasonable expectation of privacy? So now you have these two kind of parallel ideas, the old physical trespass idea and this newer reasonable expectation of privacy idea, and both become really, really important in the Jardines case.
Got it. Two different lenses to look through. So let's get to the decision. Justice Scalia wrote the majority opinion saying, yes, the dog sniff was a search. How did he get there? What was his reasoning?
Well, Scalia really leaned heavily on that older traditional property rights idea, the physical intrusion. His argument started with the porch itself. He said the front porch is part of the curtilage of the home. That's a legal term, basically meaning the area immediately surrounding your house that's closely linked to it, like part of your home life. And for Fourth Amendment purposes, the curtilage gets the same strong protection as the inside of your house.
So the porch isn't just like a public sidewalk leading to the door. In Scalia's view, it's basically an extension of the home itself.
Exactly. It's constitutionally protected space. Now, Scalia acknowledged that, yes, the public, including police, generally have an implied license to walk up to your front door.
Yeah.
To knock, maybe ask a question, what they call a knock and talk. But, he argued, bringing a specialized drug-sniffing dog onto that porch specifically to gather evidence. That goes way beyond the scope of that implied permission.
So the dog itself was the key difference for him. It wasn't just an officer walking up.
Right. He saw the dog as more than just an animal using its natural senses. He specifically called it a device, or an instrument. Something not in general public use, designed specifically to find hidden evidence. And he directly connected this to an earlier case, Kylo v. United States. In Kylo, the court said using a thermal imager to scan a house for heat signatures trying to find grow lamps was a search. Scalia saw a parallel. Both the thermal imager and the drug dog are tools used to get information from inside the home that you wouldn't otherwise know without physically going in. So for Scalia, it boiled down to this: physically entering the curtilage, using the specialized tool, the dog, for the purpose of investigating, that's a trespass, and therefore it's a search.
Okay, that's a clear line based on property rights and trespass. But as you said, there was a dissent. Justice Alito saw it completely differently. He argued it was not a search. What was his take?
Alito came at it from the other angle we talked about, the reasonable expectation of privacy test from the Katz case. His main point was about what the dog sniff actually reveals. He argued that a drug dog sniff is, well, unique. It's sui generis, he called it, because it only detects the presence or absence of illegal drugs, contraband. And the reasoning goes, since you don't have a legitimate expectation of privacy in possessing illegal things, a technique that only reveals illegal things can't violate your reasonable expectation of privacy. Therefore, it's not a search under the Earth Amendment.
Okay. So his logic is, if the only information the police get is drugs or no drugs, and you have no right to privacy in drugs anyway, then no protected privacy interest was actually violated by the sniff itself.
That's the core of it. Alito also stressed that the police were legally allowed to be on the walkway approaching the front door just like any delivery person or visitor. They weren't trespassing just by being there. And he argued that using the dog's super-sensitive nose wasn't fundamentally different from an officer using their own senses, or for that matter, using other tools the court had already approved in other contexts. He pointed to things like using a flashlight to see into a car, or binoculars, or even taking aerial photos from public airspace. He mentioned cases like Illinois v. Cabayas, which allowed a dog sniff of a car during a traffic stop. He also cited cases allowing surveillance of backyards from helicopters, like California v. Serralo and Florida v. Riley. His point was, if the police are in a lawful spot and they use a sense-enhancing method that only detects illegal activity, it shouldn't count as a search.
So if an officer themselves could smell marijuana wafting from the house while standing on the porch, that clearly wouldn't be a search. Alito's basically asking, why is using a dog's nose, which is just a more sensitive version of smell, constitutionally different?
That's precisely his question. He felt the majority's focus on the physical trespass idea was too rigid, too stuck in the past, maybe, not really adapting to modern law enforcement tools and techniques. So, for Alito, lawful presence plus dog sniff revealing only contraband, no violation of a reasonable expectation of privacy, not a Fourth Amendment search.
Wow. Okay, so two really distinct ways of thinking about the Fourth Amendment colliding over this one incident with Frankie the dog.
Yeah.
We have Scalia focused on the physical intrusion onto protected property.
Right, the trespass onto the curtilage with a specialized tool.
And then Alito focused on whether a legitimate expectation of privacy was violated, arguing that detecting only contraband doesn't count.
Exactly. It really highlights this fundamental tension that runs through so much of Fourth Amendment law.
So, stepping back from the legal arguments for a second, what does this all mean for us, for you listening? We've got the highest court split on something that happens right at your front door. What are the real-world takeaways here?
Well, I think this deep dive really throws that ongoing tension into sharp relief, doesn't it? On one side, you have this really strong protection for physical property, the idea that your home and the area right around it are sacred, almost. That's the trespass view Scalia championed. But then on the other side, you have this idea pushed by Alito that the Fourth Amendment is mainly about protecting legitimate privacy.
Yeah.
It's not there to help people hide illegal activities.
Yeah, it forces us to think about where exactly that line is. What defines the boundary of private when technology, or even, a well-trained animal, can sense things we can't?
Absolutely. The Jardines case is a perfect example of how new methods, whether it's a thermal camera like in Kylo or Frankie's nose, force the courts and us as a society to constantly reassess what we mean by a search. What kind of protection do you actually have around your home in the face of these evolving techniques? It's this continuous back and forth, trying to balance your individual rights against the needs of public safety and law enforcement. It's never really settled.
What a fascinating deep dive. Privacy, property rights, the power of a dog's nose. Who knew it could get so complex? We've seen the Supreme Court fundamentally disagree on whether a dog sniffing at your front door is even a search under the Constitution. And it really reflects these two deep currents in how we think about our rights, the sanctity of physical space versus the protection of legitimate privacy expectations.
It definitely underscores that the legal rules around your own home, even the edges of it, are not always clear-cut. And the tools police use, even ones that seem kind of low-tech like a dog, can really shift the boundaries of your Fourth Amendment privacy.
Right. It's not just some abstract legal debate about dogs or drugs. It's really about that constantly shifting line between what's considered public space and what's considered your private zone. And how seemingly small details about police procedures can have massive consequences for your constitutional rights. It really drives home that these arguments are about your fundamental freedoms. So, as we finish up this deep dive, here's something for you to chew on. Thinking beyond drug dogs or thermal imagers, what other everyday actions or common tools could potentially cross that line? When does something ordinary, if adapted by law enforcement, become an unconstitutional search of your home? And maybe more importantly, how do we as a society figure out where that line should be drawn?